I'll pay you $50,000 more, though, if you get me an acquittal. What about that?
Your Honor, I think Justice Mullen's observation about the conflict of interest shadow that is cast upon the advice which counsel gave to his client at that juncture.
My cases where counsel has advised him to take the plea, there's been plea negotiations, and he says, no, I don't want lesser included, I don't want to take a plea, I want to either be acquitted or found guilty, go on with my trial, and there's $50,000 extra if I'm acquitted.
First, the only way that this could be determined would be through a hearing. And if such a hearing were held, I submit that the court, the trial court, should not give weight to the attorney who has already proven himself to be one who can flagrantly violate the Code of Professional Responsibility. I don't think that a trial court should, as a matter of law, give that attorney the benefit of the doubt and assume that what that attorney is saying is true. As a matter of law, it must be assumed that that lawyer, in his efforts to negotiate...
a liar too, huh?
I don't think that as a matter of law, it's a meaningful distinction to make, to say that yes, he's unethical, yes, he will enter into an agreement that unethically strikes at the heart of the attorney-client relationship, yet we can rely upon him when he takes the oath. And we also have a defendant who is in desperate need of an attorney with undivided interests at the very outset of the proceedings, when he's arrested, when investigation has to be done, and perhaps investigation into lesser included, or perhaps a look to see if there's a possibility or there's an opportunity for plea negotiations that can be seized upon but may later be lost. And these are things that are lost at the hearing phase. I don't think that we should hold the defendant to any kind of burden such as the court is suggesting by its questions. I also submit that the second reason for the per se rule, not only is there an actual conflict of interest, but assuming for the sake of argument that there is merely the significant possibility of a conflict of interest, Gomberg, as I had suggested before, and as Justice Mullen clearly stated, is impossible to comply with. There cannot be inquiry because the court will simply not know of the agreement ahead of time. If I may, in the time remaining, I would like to point out that in United States ex rel Simon versus Murphy, cited by the district attorney in her brief, the court stated, and I quote, "It is hard to imagine a more striking example of blatant conflict between personal interest and professional duty." And I submit that if this court follows its precedent, this precedent mandates that in such a blatant conflict, reversal is mandated. If there are no further questions.
Thank you very much.
Thank you, Your Honor.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence, and appear here tomorrow afternoon at 2 o'clock, at which time this Court now stands adjourned.